Do you know what the phrase mitigation of damages means? Well, if you're bringing a lawsuit in the state of New York, you definitely need to know what it means. Come join me and I'll share with you exactly what it means. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. Mitigation of damages is used when you've suffered some type of injury as a result of an accident case or as a result of a medical negligence or medical malpractice case. When you suffer an injury, the law requires that you try and mitigate your damages. Now, what does that mean? It means that if you have an opportunity to reduce the extent of your injury, of your disability, you have an obligation to actually do that. So in other words, if there's medical treatment that will help alleviate the problems you're having, well then you're expected to go ahead with that treatment. If there's something else that you can do that will minimize the pain and the suffering that you are experiencing, again, the law requires that you take steps to minimize and reduce the amount of suffering and the pain that you're experiencing. It makes sense, doesn't it? You don't want to sit around and wait for a payday just because you've suffered an injury and expect that you'll get more by not trying to reduce the amount of your damages and your injuries. So the law actually puts that burden on you, the injured victim. A lot of people think that if they get injured in a car accident, if they get injured by tripping over a defective sidewalk, or something else happens, that they can simply accept those injuries and try and get compensated for the results of those injuries. Well, they can. But again, at the end of your trial, the judge is going to instruct the jury that you, the injured victim, has an absolute obligation to minimize and reduce the extent of your injuries if possible. Now, there may be valid reasons why you are unable to go forward and get certain types of treatments. You may be afraid to have surgery to correct the problem. You may not be able to have other types of treatment that will help reduce or minimize your injuries. So those are things that the jury will have to take into consideration when evaluating whether you affirmatively went ahead and tried to make your life better and minimize the injuries that you actually suffered. So why do I tell you about this? I tell you about this because chances are you have questions and concerns about your own accident matter or medical malpractice matter. And if your matter happened here in the state of New York, what I encourage you to do is pick up the phone and call me. I answer legal questions like yours every single day. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks for watching.